Hello, I figured it was time to introduce myself because I'm pretty new to this here TikTok thing. But hi, I'm Mackenzie Joy Brennan. I am an attorney. I focus on constitutional law and judicial bypass, which is the procedure required for minors who are seeking abortions without parental consent. So I'm one of two attorneys who do that here in Maricopa County, Arizona. Before this, I used to work for the New York Supreme Court. So I've got some constitutional and government background there and some abortion law background out here. And I also make stuff to demystify law and policy. And you can find some of that obviously here at MKZ Joy Brennan on Instagram as well. And I do a kooky little newsletter. If you want to subscribe, it's free at mkzjoybrennan.substack.com. And I really hope you hang out and learn stuff with me, because shit's fucked up. Okay, bye. Hello, my name is Mackenzie Brennan, and I'm a lawyer. I'm one of two lawyers in Maricopa County, Arizona, who represents young people who are seeking abortions, and I'm somebody who's had an abortion. So for the 1-year anniversary without Roe v. Wade, after the Dobbs decision last year, I thought I would do some myth dispelling, just to sympathize and re-up the conversation. So one thing that judges ask my clients, so young people, teenagers who are trying to seek abortions without parental consent, one thing they get asked all the time is about the inevitable regret. And again, as somebody who has had an abortion myself, I can confirm that this is not always the case, even though you also hear in the media mostly about the more tragic stories, because they do highlight how dire things are. So I always like to tell my clients that this is something they kind of have to parrot back to a judge, like, yes, I understand this could happen, but between you and me, like with just us chickens, that is not something that is inevitable. In fact, a lot of people feel nothing. A lot of people feel immense relief, if not anything else. And especially when you're a young person, I think that this is entirely normal. And hell, I wasn't even that young when I had my abortion, so I think any age that's super normal. And I mean, you do have to say to the judge that you understand what they're saying, and yes, I will cope with it super well. But studies have found that 95% of women who have abortions, and this was done in the framework of women, but it includes people who have a uterus, who can get pregnant, who have abortions, who don't identify as women, 95% of them do not regret their abortion. Another study of minors in 2001 showed that minors don't suffer any greater long-term repercussions or psychological consequences or regret than their adult counterparts. So, myth number one that we're dispelling in honor of the deceased precedent of Roe v. Wade is that abortion is accompanied with regret. If it is for you, that is totally fine, and that is entirely your right, but it is by no means something that goes without saying. I hope you follow me for more weird social issue law talk, and certainly if you have any questions about abortion or abortion law, I am at MKZ Joy Brennan on Instagram and most other platforms, and you can also subscribe to my Substack at mkzjoybrennan.substack.com, and I would love to have you. It's free. Bye. Hello again, I'm Mackenzie Joy Brennan. I am one of two attorneys for minors who need abortions in Maricopa County, Arizona, and I've also had an abortion. So for the 1-year anniversary post losing Roe v. Wade, I'm dispelling some myths about abortion, the medicine behind it, and the law behind it. So today I wanted to talk about how the law treats abortion differently than it does any other medical procedure, which is really wild. And it's not really talked about a ton, but if you think about it, it does become kind of obvious. Legislatures and lawmakers and politicians don't spend a lot of attention on passing laws and, stirring up rhetoric about regulating other medical procedures because the medical profession already does that. Things like timing or type of medication or who can make these decisions, those laws already exist. Those protections already exist. It's involved in medical licensing, in facility licensing, prescription licensing, things like that. So think about how much time you hear spent on the politics and laws behind, for example, wisdom teeth extractions. And this is a great example because actually getting your wisdom teeth removed is a procedure that is riskier than even surgical abortion. So, like I said, medicine already provides the regulatory framework that is sufficient to support things like patient consent and safety and best practices, even in medical decisions that are far more complex than abortion. So one thing that I wanted to add to underscore how ridiculous this is and underscore how safe abortion actually is an annual CDC survey of abortion outcomes that took place before the Dobbs decision, so while Roe was still in place. So this survey that was again done by the CDC, so pretty well vetted, we know that through COVID, it reported 600,000 annual abortions that were, medically documented and reported in the year that they were studying. And of that 600,000 in the US, there were only 4 abortion-related deaths. So the percentage there, that is a 0.0007% mortality rate of abortion. So let's compare that to appendectomies, which are pretty low risk in general outpatient procedures, just like abortion, except they're a lot more risky and nobody gets bent out of shape about them. So compare the 0.0007% mortality rate of abortion to over 1% mortality in appendectomies. Still not bad, but gives you a sense of comparison. All right, thank you so much for hanging out. Follow me at mkzjoybrennan, and if you want to subscribe to my newsletter, it's mkzjoybrennan.substack.com. Did you know that in 36 states, even if you otherwise qualify for a legal abortion, if you're under 18 and don't have parental permission, you still can't get one? I'm Mackenzie Joy Brennan. I am a judicial bypass attorney helping minors get abortion in Maricopa County, Arizona. And I'm dispelling some myths about abortion for the 1-year anniversary of losing Roe v. Wade. Oh yeah, I've also had an abortion. So these parental involvement abortion laws may kind of seem like a good idea if you initially think about, protecting minors, but ultimately they really just end up preventing minors from accessing abortion. So there is a type of procedure that has been designed by the Supreme Court in the 70s to allow a judge to sign off on a minor's abortion if they don't have parental consent. So that's what's called judicial bypass, and that's the kind of work that I do. It's not perfect because obviously we don't want any third party having a sort of absolute veto over anybody's right to access an abortion. But at the very least, under the current system, there is that alternative. It's kind of scary because the only reason that there was a judicial bypass alternative created is Roe's constitutional right. So without Roe, this is kind of tenuous and on the table. My cat is eating her feet. But in any case, that's what judicial bypass is. If you are in one of the states that requires this, and you probably are because the majority of states do require this, it's worth learning more, volunteering your time. I am one of only 2 attorneys who does this in Maricopa County, which is where Phoenix is located. So, hey, if you're a lawyer or even somebody who wants to volunteer in Maricopa County, please let me know. You can find me, there's the cat. You can find me at mkzjoybrennan on Instagram and this platform, and you can also go to mkzjoybrennan.com. Hi, I'm Mackenzie Joy Brennan. I'm an Arizona abortion attorney, and I've had an abortion myself. So I'm going through some of the legal hurdles that people have to clear to obtain abortions, both after Roe v. Wade, and honestly, for this one, it was true even before Roe v. Wade was repealed. So in one of my prior videos, I talked about the parental consent hurdles that minors who are seeking abortions have to clear in 36 out of the 50 states. And the alternative to this is a procedure called judicial bypass, which allows minors to instead have the super fun task as a teenager or even younger of, instead of asking their parents for permission, convincing a judge through a petition and hearing that they deserve a judicial bypass to parental consent in order to get their abortion. Obviously, this sucks and is difficult for a lot of reasons. And it also applies on top of all these state-based restrictions that have been passed since the Dobbs decision. But today I wanted to talk a little bit about the legal standard for judicial bypass hearings. So if a minor wants an abortion, doesn't have parental consent, and lives in a state where they need parental consent, they have to go before a judge and petition and have a hearing to prove that they are allowed to have an abortion. Obviously, the judge makes a huge difference in this because you get an anti-choice judge and you're out before you're even in. But even the good ones, the legal standard is a bit of a mess. So there's very little clear nationwide guidance on what is required to grant a minor's judicial bypass petition. The only clear guidance that the Supreme Court has given was in the 70s, and virtually all the court wrote was that a minor must show that she is mature and well enough informed to make the decision to get an abortion. Obviously, that is super subjective and doesn't give any concrete factors that need to be satisfied. So the first problem with this is that it allows states to make up their own crazy, subjective, unrelated hurdles, and boy have they. But let's just look at the well enough informed and mature prong, because that causes enough problems on its own. First of all, if she's not mature enough to get an abortion in the court's eyes, the punishment for that and the outcome is that she must instead become a parent. So she's too immature to have an abortion, so she has to bear a child. On paper, that standard seems to basically invalidate itself. On the other hand, confusingly enough, the fact that this child has found out that judicial bypass is required, filed a court petition, and showed up for a hearing, that to me is evidence of being well-informed and mature all on its own. So by that standard, they really shouldn't even have to go through the hearing if they've gotten to the point that they've petitioned the court. So the standard is self-invalidating and self-proving. Either way, in practice, best case scenario, these type of standards, they have requirements that reach far beyond somebody's preparation for a preventative outpatient procedure, which is what a surgical abortion is, certainly what a medication abortion is. It's super easy. You can watch some of my videos about that. I've had an abortion. I lived to tell the tale and then some. Honestly, standards like mature and well-informed seem more appropriate to determine parental fitness, not abortion fitness. So in any case, that's a little bit on judicial bypass for minors seeking abortions. I'm Mackenzie Joy Brennan. You can follow me on Instagram and TikTok at MKZJoyBrennan. And if you're interested in a fancier newsletter, you can subscribe at mkzjoybrennan.substack.com. So, it has been a year since the Dobbs decision overturned Roe v. Wade and got rid of the national constitutional right to abortion. If you're like me, you have probably heard a lot of people, certainly a year ago, talk about how worried they are that this would affect other rights. So today I want to address some of that. Unfortunately, that is a very real and very big risk. Roe v. Wade was based on due process and the right to liberty that is contained in the due process clauses in the Constitution. So the right to not be deprived of life, liberty, or property. The liberty part of that, and the fact that you can't be deprived of it without due process, is what was read to encompass things like bodily integrity, privacy, other non-enumerated, non-listed rights in the Constitution. They also looked at things like the right against quartering soldiers in your home or unreasonable search and seizure, and kind of looked at the shadows cast by those rights and said, there's a right to privacy in there, and that's probably what liberty was intended to cover, if not, your life, which is already listed. So that substantive due process is what covered things like birth control and part of the right to gay marriage. So if we pull Roe, which we have, that whole substantive due process thing goes out the window as well. And that means a lot of other precedents are threatened. So that's 60 seconds on the ominous portend of the Dobbs decision last year that overturned Roe v. Wade. So keep an eye out. There was even a footnote, I think by Clarence Thomas, that said, we should re-examine Obergefell, which is gay rights, next. So a lot of these things are on the chopping block. We love substantive due process. It had been precedent for 50 years. So not to tell everybody to be afraid, but be kind of afraid and stay vigilant and stay mad. I'm Mackenzie Joy Brennan. You can find me at MKZ Joy Brennan, or you can read longer versions of this yammering at mkzjoybrennan.substack.com. Hi, I'm Mackenzie Brennan. So I represent minors in a legal proceeding called a judicial bypass, which is when minors are seeking abortions without parental consent. And so after doing a couple hearings this week with 15 and 16-year-olds who have to find rides to the clinic, and then find out that they have to do 2 different rides because we have a 24-hour waiting period here in Arizona, I figured I'd do a little video on abortion 24-hour waiting period laws. So again, when I go through these legal requirements, think about the fact that we are talking about, in many cases, a 15 or 16-year-old who can't necessarily drive, doesn't necessarily have the ability to tell their parents where they're going if they are driving, has to get gas money, time off school or work, like coverage from the people in their lives, chaperone if they want it, for now 2 different days. And from there, let's dive into what the law required. A side note here, because the Arizona statute calls this the informed consent law, I want to remind everybody that the medical profession already provides for and requires informed consent legally in every medical procedure, and in no other procedures do we have to go like definitional surgery by surgery and rewrite what informed consent means, but that is what we've done in Arizona, and it's really not informed consent. It's just like pseudo-real information to scare people away from getting an abortion. So in Arizona, per statute, at least 24 hours to the procedure, which is really just designed to make people come back after making a whole trip and thus chilling access, the actual physician must inform orally and in person a prospective patient of the following: the nature of the procedure, the name of the person who will perform it, risks of the long-term risks of abortion, the available alternatives to abortion, the probable age, the probable physiological characteristics of the probable favorite snack of the fetus if it's born and lives another 10 years. Okay, so I made that last one up. I'm really shocked that the law doesn't require us to remind patients of the fact that the fetus could be a boy and thus become more of a person than the pregnant vessel herself. Also, this isn't the exhaustive list because other employees like counselors, nurses, physician's assistants have to inform the patient of even more details, which include things that aren't quite true either, like the fact that a father would have to pay benefits and be guaranteed to offer child support in the event that a pregnant person gives birth. But that's not true. We know that's not fully enforceable. So that's today's primer on the super cool little hoops that a pregnant person has to jump through if they just want to go in for a simple outpatient procedure in Arizona.